Yes, video lecture 6. We're going to continue with judicial protection this week and enforcement of EU law. Remember last week we talked about the first procedures that are part of this topic, namely preliminary reference of Article 267. We talked about the enforcement against member states, Article 258, and we talked about Article 259, which is member state against another member state, but again via the Commission, remember? So this was about the situation for the preliminary reference where a national court refers a question to Luxembourg, and in the case of Article 258 or 259, when the European Commission enforces rules on member states and when they don't comply with the rules. Today we're going to talk about something else. We're going to talk about annulment mainly. Annulment, so trying to annul something, means you try to cancel something, stop something. And this is the case, for example, if you get a fine by the European Commission. Imagine you're a big company like Google, you get imposed a fine of 1 billion for practices that go against EU competition policy. Then you want to have that fine annulled. You want to have it off the table. And that goes via Article 263. And that's the bulk of what we're going to discuss today. So the same pictures as last week. I don't need to say a lot about that. So here we see the outline. As I mentioned, mainly Article 263 will introduce the procedure, the appeal for annulment. Then we make a distinction between so-called privileged, semi-privileged and non-privileged parties, and that distinction can simply be found in the Article 263. If you read it, you will find it there if you read it carefully. And then we talk about a so-called locus standi, which is a fancy Latin word for admissibility for non-privileged parties. And then we go into the issue, the complex issue, I have to warn you, of direct and individual concern. And then the last slide, I believe, is on the failure to act procedure, which is the last judicial protection enforcement article that we will discuss. So, the annulment procedure, what is it? What are the key features? Well, the appeal can be aimed at legislative acts and other acts of EU institutions, so that's the first typical feature of this article. Please remember when we discuss articles always to look at the source itself, so carefully read Article 263. Maybe stop the video now and first read the article carefully so you know what the article is about. That always helps in memorizing things and properly understanding things. So yeah, you see there that this article can be used against acts of EU institutions, so legislative acts or other acts, and then of course we're mainly talking about decisions. If these acts create rights and obligations vis-à-vis third parties, vis-à-vis means in relation to third parties, so remember the issue of rights and obligations is very important. If something creates a certain right for a party or an obligation for another party, this can be something that you want to have made undone because you don't like to have this obligation, for example, or you don't want the other person to have the right, or you don't, well, anyway, there are variations on this. If the act is annulled, it is legally spoken non-existent. So basically, if you manage to go to court under Article 263 and the Court of Justice annuls the act, then it is non-existent, meaning that you no longer have to follow it. So which are the parties that can actually go to court? Again, you see it in Article 263, and we're going to elaborate on it now. But in brief, it can be an EU institution, commission or council or whatever, or also individuals, or companies, natural persons, and so on. So let's elaborate a bit more on that issue of who is the party, which party can actually ask for the annulment of an act. Now we have to distinguish them between privileged, semi-privileged and non-privileged parties, simply following the structure of the article. of Article 263. And this is the question of locus standi, the Latin concept locus standi, meaning that you need to have locus standi if you want to start proceedings at the court. If you do not have locus standi, it means that you can't pursue your proceedings. You cannot basically bring your case to the court. So it's an admissibility. It basically means that your claim is admissible by the court. The court can listen to you and go into the merits of your case. So this is very important. So, to start with the first box, locus standi is Latin, aims to express that the party has access to a procedure, so that the claim is admissible. It does not mean that you win the case, of course. It only means that the court will look at your case and will give a judgment, either saying yes, this act should be annulled, or no, it should not be annulled. Yeah, so it's only a formal step. But it's very important because if you don't have locus standi, the court can't even deal with your case. By the way, this is a very general distinction that you always have in legal cases anywhere. In the EU, in a local level, in your daily life, if you would ever run into issues with the law, I don't hope so, there are always these two stages. The admissibility stage, can we actually go to court, and then the merits case, so the substantive phase, when the court actually looks at your case and will decide in favor of you or against you. Alright, so let's go to the parties. Who are these parties? So the privileged parties, and the word already says it, are privileged, meaning that they have broad access to the court. Yes? So their locus standi is very relatively simple. The privileged parties are the member states and the EU institutions. You can find that in the articles. And they are privileged because no special requirements need to be fulfilled. That's quite simple. Then we have, as a second group, the semi-privileged parties. So they are somewhere in between the ones that are really privileged and the ones that are not privileged, that we'll discuss in a second. The semi-privileged parties are the European Central Bank, the Committee of the Regions, the Court of Auditors. Again mentioned in the article, they can only access the procedure to protect their prerogatives. Yes, so they can't go to court for other reasons, only when it's about their prerogatives. They have to do with their rights and obligations, and their powers, basically, as it says on the slide. So if an act, a decision, for example, by the European Commission affects the European Central Bank directly, it affects the power of the European Central Bank, then it has locus standi, then it can actually go to court. But if it doesn't, it won't have locus standi, so the court will not look at the case. Now, the non-privileged part is the last group. That's the most problematic group. And maybe for many of you also the most interesting group, because it potentially would include yourselves, natural persons, legal persons. Now, for non-privileged parties to have locus standi is very difficult. And there's a logic behind that, because if any one, or let's say any of the 500 million Europeans could easily go to court, would have locus standi to fight all kinds of decisions, directives, regulations, you name it, then the court would be, of course, basically defunct, because it would collapse under all the cases. It would no longer be able to fulfill its function. Yeah, so it's logical that there are non-privileged parties and that they need to fulfill very strict conditions in order to get to court. Yeah, so non-privileged parties are natural and legal persons. So legal persons are companies, for example. They need to fulfill tough conditions to get access to the procedure. General Court, GC, that's written there because that's the court where individuals, legal persons or natural persons, first go. And then later there's sometimes a possibility for appeal at the Court of Justice of the EU, but the General Court is the first court where they start their proceedings. Okay, so let's get a bit more, so we're going a bit more deeper now into this situation of the non-privileged parties. If you carefully read Article 263 on the non-privileged parties, you will find there that they need to show a direct and individual concern. Okay, but this is only the case, and that we see here on the second point, if the act is not addressed to them. Yeah, so this is very important that you distinguish this. So let's take a company as an example. Yeah, Google. Google gets a fine by the European Commission. Google gets fined because it's violating competition rules by favoring its own search results. Can Google go to court and annul the decision? The answer is yes, it has locus standi. It does not need to show direct and individual concern in this case. Why not? Because the act is addressed at Google. Google gets the decision, gets the fine. Yeah? So the direct and individual concern question is only relevant in case the act is not addressed to that person, to that legal person. Yeah? Alright, so as it says on the slides, individuals have access if the act is addressed to them, or if the act is addressed to a member state, an institution, or other individual, but of direct and individual concern to them. Yeah? So this is the case when the act is not aimed at you, but you feel that your rights are affected. And in that case, you have to show direct and individual concern. But then we still don't know a lot. We just know that non-privileged parties, if the act is not addressed to them, they have to show direct and individual concern. Well, what is it? How do we do that? And that's when, again, the case law comes in. So the judgments of the Court of Justice. And we discussed three judgments to try to make that clear. It's Differdange, Plowman, and Töpfer. So this is important case law that we expect you to know at the exam. Remember, there's a list on Blackboard with all the important case law that we expect you to be able to work with and to know. And these are definitely three examples of that. So the Differdange case. The Differdange case is the first case in which we will go into these direct and individual concerns for non-privileged parties. Now we start with direct concern because that was the key criterion that was decided upon in this case. The case was about a municipality in Luxembourg, the municipality of Differdange, and the act that this municipality tried to see annulled was a decision by the Commission to support Luxembourg in providing state aid to its municipalities in order to restructure their steel industry and modernize it, basically. So very complex, maybe. I'll say it one more time so we know what we're talking about. We have a municipality, Differdange, and that municipality, Differdange, went to try to annul a decision by the European Commission, yeah, as a non-privileged party. It tried to annul a decision of the European Commission, and the substance of that decision by the European Commission was that it allowed Luxembourg to close down, or to that's not entirely correct, but to provide state aid in order to restructure and eventually close down certain steel industries within its territory. Now, why did Differdange go to court? Because it feared that it had a big steel industry, of course, there. It feared that their steel industry would be made smaller, and that would lead to less tax revenues. Yeah, so Differdange, then the municipality, had an interest. It said, listen, we will get less tax from the steel industry if Luxembourg, our central government, is allowed to restructure it and to provide a certain state aid in order to produce less steel and eventually maybe even close the entire steel mines here. That is all negative for us. So we also have a direct concern here. I hope the case is clear. If not, then we can go through it again in the lecture, or you can listen to it again. So the question here was, and just to make it clear, we have basically three parties here. We have the European Commission, we have Luxembourg, the central government, and we have the municipality of Differdange. Yeah. Now, Luxembourg, the central government of Luxembourg, was asking for permission by the European Commission to provide state aid, yeah, so to give money to the steel industries in order for them to produce less, yeah, because it wanted to reform them. And so they compensate with the state aid money, they give money to the steel industries to compensate for their lower production. That's the decision that was on the table. The European Commission said, yes, we find this a good idea, we grant you this permission. Now the third party, the municipality of Differdange, that was the party that was worried for the effects it would have on them. Because they said, well, listen, we will miss tax income. So the question is, this party was not, the municipality was not the party to which this act was addressed. The act was not addressed at the municipality. So the question is, did it have direct concern? Now, the answer here was, in this case, the court said no. It does not have a direct concern because the decision itself is not, let's say, specific enough that it would be about Differdange. It's a general decision that says, yes, Luxembourg, you can give state aid to reduce the steel production in your country, but it didn't say specifically which municipalities would be affected. That was still for Luxembourg central government to decide. So there was no direct link between the decision and the potential effects for Differdange. So in this case, there was still a margin of discretion left for Luxembourg to implement the decision in the way it wanted to do it. Yeah? So there was no immediate effect on the legal position of the municipality of Differdange. Yeah? So that's for direct concern. So there should always be an immediate effect of this act, and there should be no discretion margin left for authorities to implement measures. I hope this is clear. If not, we can talk about it further on in the seminars and the lecture. The next aspect is individual concern. So we now know what direct concern is, but what about individual concern? And here we use the Plowman case to make that clear. Plowman was an importer of tangerines. That's why we see tangerines on the picture on the left. And Plowman was, you see it's a German name, was a German importer of clementines. So a private party, an individual. Now, Plowman was also protesting and wanted to see a certain decision annulled. What was the decision? The decision was that the German government was allowed by the European Commission to change the import duties for tangerines. Yeah? Make them more expensive, basically. This is important to understand if you want, because you might get confused. This was in the time when these countries still could have these duties that they would set individually. So it's a long time ago. But of course they had to have permission by the European Commission for doing so. Yeah. So Germany wanted to change the duty, make it basically put, let's say, more duty on these tangerines. It asked for permission at the European Commission. The European Commission said to Germany, yes, you can do this. Yeah. So the act was addressed at Germany. And then Plowman, a third party, said, hey, this act is not addressed to me, but I do have individual concern and direct concern here. Now, the direct concern is not a problem here. The duty was changed, and yeah, there were no further implementing measures, so we don't have this whole Differdange story here, but the individual concern is the important part here. And the Court of Justice ruled in this case that you only have individual concern if you are so distinguished as an individual that you are part of a closed group, yeah, a closed class of other individuals, that is really different from all the others. Yeah? So you are singled out actually in the same way as the actual addressee of the decision. So, in other words, this is an extremely restrictive interpretation of what it means to have individual concern. Because the outcome here, in this case, was that the court ruled that Plowman did not have individual concern, because it was not sufficiently distinguished and singled out as part of a closed class that could not change, yeah, when the decision was taken. Because any tangerine importer could potentially join Plowman in the same situation. So he was not sufficiently part of an identifiable closed group to be considered individually concerned. Yeah. Now you do understand, hopefully, that this is an interpretation the court developed that makes it extremely difficult to have access to Article 263 as a non-privileged party in the case you are not the addressee of the decision. Now, you might say, okay, but do you have an example of a situation where this did work and where some non-privileged party did have individual concern in the criteria under the criterion of the court? That is very restrictive criterion. Yes, that case exists. There are some other cases as well, but the one that we decided to deal with in this lecture is this case, the Töpfer case. This very strict test that was developed in the Plowman case for individual concern, namely that you have to be part of a closed group of subjects, and you must actually be identifiable almost in the same way as the addressee of the decision, was this very strict test. The question was, of course, will that ever be met by any party? And the answer is yes, in Töpfer. So in the Töpfer case, we see an example of a situation where an applicant, a non-privileged party, did get access to the proceedings because he was individually concerned and directly concerned. Töpfer was a corn importer in Germany, and he had applied for an import license to import corn, a certain quantity of corn, on a certain day. I think it was the 1st of October, 1963 maybe. And he had acted on information of a certain percentage he had to pay on duties and so on, which was favorable. That's why he applied for this import license. And the German government decided, seeing that they made a mistake with that percentage, that they decided not to grant the import license. And that decision had to be supported again by the European Commission. So the European Commission had to decide, are we going to support Germany in this decision not to grant these import licenses to Töpfer and a few other corn importers that had done the same thing on the same day? Now the question arose again here, is Töpfer part of a closed group of identifiable subjects that we can equate almost to the addressee of the decision? Now who was the addressee of the decision here? It was the German government. Yes, so the European Commission decided, granted the decision to Germany, saying yes, you are allowed not to grant these import licenses for this particular group of importers. Now, if we use the Plowman test here, that there has to be a closed group of identifiable subjects that can't change, and only in that situation there's individual concern. In this case, we actually reach the conclusion that yes, Töpfer is part of a closed group that cannot change and is actually more or less the same as the addressee of the decision. Because basically we're talking about one day, a closed time frame of 1 October, whatever the date was. On that particular day, Töpfer and some other corn importers applied for this import license. And for that group of identifiable subjects that can never change anymore, this decision was taken. Yeah. So in this case you could say, and the court said indeed, yes, Töpfer is individually affected. So the big difference with the Clementine case of Plowman was that in the Plowman case, This was an open category of tangerine importers that could have tried to apply it, have tried to annul this general decision on the import duty. Whereas in Töpfer, there's this particular decision that is aimed at a certain group of corn importers for a particular day. So that's the difference. Now, this is kind of complex, and maybe we should spend some more time in the seminar or in the lecture to try to distinguish everything and outline everything so we are clear on what individual concern is and when it's applicable. The last part of the discussion of Article 263 are the review grounds. Yes? So once we have locus standi, once we can go to court, either as a privileged party, a semi-privileged party, or a non-privileged party, either via direct or individual concern or as the addressee of the decision. Once we have locus standi, we go into the proceedings, then the question is, what are the review grounds? What does the court actually look at? When does it say a certain act should be annulled? And there's a good reason for annulling it. Again, you can find these grounds in Article 263. Great. Now, what are these grounds? Lack of competence is the first one. Infringement of an essential procedural requirement is the second one. Infringement of the treaties or of any rule of law relating to their application, or misuse of powers. Now, as it says on the third point here, please note that these grounds can overlap, and it's common that more than one ground will be brought forward by the parties. What should we think of? Well, lack of competence, that's a nice link to what you've learned before about legal basis, remember? And the principle of attribution, one of these key principles. If there's not a clear legal basis for an EU institution to act, yeah, that means there's no competence, then of course this act can be annulled. Yeah. Infringement of an essential procedural requirement refers to certain procedural steps that need to be taken by the institutions in order to create a certain act that are not observed properly. For example, the European Parliament has to give its opinion in a certain procedure, and the institutions forget to ask the European Parliament for its opinion. Or they use a different procedure in which the European Parliament is not involved, just to not have all these annoying parliamentarians giving their opinions and amendments and so on. Yeah. So in those cases you can say, wait, there's an essential procedural requirement that should have been followed, namely the Parliament should have been heard, and it was not involved, so therefore we annul the piece of legislation that we have in front of us. Directive, for example. Infringement of the treaties or of any rule of law relating to their application. Now you can think of basically many articles that we have in the TFEU and maybe also the Fundamental Rights Charter that have not been properly observed. If these articles have not been observed, it can also be a basis to annul the decision. Misuse of powers refers to the situation where a power might be there, but it's used in the wrong way by an institution. So it uses its power, for example, for a different reason that it was initially created for. Yeah, but we can elaborate on this one maybe also in class to save some time. Okay. Then the last article that we haven't discussed yet, but that is also on the menu, that's the failure to act procedure. We can be relatively short on this. We are short on this article because in practice it doesn't play a very important role, but it is good for you to know that it's there. Yeah. So you could say a failure to act is the exact opposite of the annulment procedure. Yeah. So the annulment procedure, a party tries to annul a certain decision, act, or piece of legislation, and in the failure to act procedure, the opposite, it's the situation where, for example, an individual or a member state wants the institution to take a decision or to create an act, to make an act. Yeah, so it's the exact opposite. If the European Parliament, or the European Council, the Council, the Commission, or the ECB, or other bodies and agencies of the Union fail to act, this means that they should have done something, impose a fine for example, but they have not done so, as the slide says. Yeah? So then you can say, we take you to court because you should have acted and you haven't done so. And that's a failure. So the second point here, member states, the institutions, individuals may first ask the institution to define its position, administrative stage, and then if they have done that, the situation can be brought to court. That's when we get to the judicial stage. And we see a link here, a parallel with Article 258. That also has an administrative stage, and even an informal stage, and then a formal administrative stage, and then a judicial stage. This is also very common to first have the administrative stage and then the judicial stage actually going to court. So that's the last procedure for today. That also brings us to the end of the judicial protection enforcement of EU law topic. So we've discussed this week mainly Article 263 and last week Article 267 and 258-59. And well, I think the key point of today was this very complex criterion of direct and individual concern that exists for non-privileged parties that are not the addressees of acts. And there we've used some case law, Plauman, Differdange, and Töpfer, in order to try to make clear when such a non-privileged party has access to the proceedings. That is what you need to take away from this week, and the key points you need to take away from this week. And we'll also practice with this in the seminar and maybe also in class. Alright, see you in the next video. Bye bye.